Hello, I'm attorney Dan Marr from the Nashua law firm of Hamlin Kerrigan, and in this vlog I'm going to be talking about how in New Hampshire to resolve a claim, a dispute that you have with a co-owner of property that you inherit. So you inherit a piece of property from a relative and you only inherit a portion of it. Maybe you have a third interest, a half interest, whatever portion of the interest that you have, but there's somebody else that owns the property with you. It could be a situation where the property was owned by your uncle and he had a long-term girlfriend that he had held the property with as tenants in common in New Hampshire. And in tenants in common in New Hampshire, when he dies, his portion is still going through his estate. So it's going through his will, or it's going through what's called the intestacy laws, or if it's deeded into a trust, it would be going into the trust. But it's not the same as sometimes boyfriends and girlfriends or couples that are unmarried actually have the deeds go joint tenants' right survivorship. If that's the situation, you don't have an interest in the property because the I'll call girlfriend, significant other, now owns the property outright if it was joint tenants' right survivorship, unless you can show that your uncle or your relative made this deed with something called undue influence or didn't have the mental capacity. And I've had other blogs that you can look at to see the analysis that I've done in this. I've litigated those issues quite a bit. But in this situation, you have tenants in common, you have a part interest in a piece of property, and you have a dispute with the other owner. You don't have an agreement as to whether you want to sell the property, or if it's a lake property, you don't have agreements as to when you're going to be both enjoying the property. Any of those types of situations. In that circumstance, you have to do what's called a partition action. In New Hampshire, we have a partition statute that allows you to go to court and have the court address, it can be either the probate court or the superior court, address who owns the property and what the percentages are. Even if it says tenants in common and it's a undivided half interest in the property, says it in the deed, the court is allowed to go into a more of analysis as to the situation of your relative that you inherited or from. Did they make most of the contributions, the financial contributions to the property? What was the circumstances and why they bought the property? There's a lot of factors that are factored in. I've litigated these cases, but you have to first go through that process. And if you also have a situation where you have maybe a long-term girlfriend or boyfriend, significant other of this dead relative of yours that you have inherited the property from, in that situation, they may, even if they're not on the deed, they may say, well, really, he always promised me the property, and they're making some type of claim on the property. I've said in my other blog, you should go, when you have tenants, you should go through the landlord-tenant writ process when there's a dispute and make sure you get a definitive date of getting possession of the property, and there's a process for that, and you can look at the vlog that I covered 5 months ago on this. But if you go there and she's saying, or he's saying, I have an interest in the property, there's something called plea of title, and the circuit court landlord-tenant division is going to be, or district division is going to be saying, look, you have to go to superior court and you have to resolve that issue first of the plea of title. So it's better to go and do the partition action if there's a claim that they have, to flush that out, and then if they're still in the property, you can go forward with a landlord-tenant writ, and if they say, look, I have a plea of title, I have an interest in the property, well, that's already been decided in the partition action, and that's the way it is. So you can deal with it that way. I've dealt with those issues quite a bit. I strongly recommend that you, in that circumstance, go forward with the partition action, and then you can resolve the case. Litigation's a highway, there's plenty of exits, there's more than enough opportunities to deal with it, but if you're just sitting there talking to this person and it's like talking to a brick wall, move forward with these processes and go forward with the partition action. Then they have to hire an attorney and address the issues. Then they have to test their theories, what they say themselves that might not make sense. Then they have to realize they have to say it in front of a judge. You want to deal with those issues, and you want to resolve the matters because you want to move on. Often you're not going to want to share the property with this other person that your relative thought was a good idea to have the property shared with, but you don't. So in that situation, partition action, if they have a title claimant in the property, unless it was joint tenants' right survivorship, because then you don't have a right in the property unless you can challenge that underlying deed that went into the joint tenants' right survivorship. And again, for that analysis, the undue influence, mental competency, you're saying that the person was manipulated. I've done other vlogs. Please look at those vlogs, and they go into detail. I've litigated all those matters. Happy to help you if the opportunity arises. My name is Dan Marr, again, at the National Law Firm of Hamlin Kerrigan, 603-883-5501. You can reach me at 603-883-5501, or check out our website, naturalllaw.com, and my vlogs, my weekly vlogs are in there. And you also get access to our radio show that I've done weekly from December 2014 to March of 2023, all in a local radio station. And that's on our website as well. So Dan Marr, 603-883-5501. Thank you.